The Supreme Court takes the meaning of words very seriously. This is especially so in the interpretation of the Fourth Amendment. That one word that distinguishes this amendment, and really distinguishes American law enforcement practices from most others, is reasonable. Law enforcement officers must be reasonable in their searches and seizures. No more, no less. Let's take the case of Illinois versus Rodriguez. Gail Fisher had a troubled relationship with Eddie Rodriguez. Gail lived with Eddie for approximately 6 months. The arrangement didn't work out so well, and they both went their separate ways. Several weeks after she moved out, Gail's mother became so distraught over the physical appearance of her daughter that she contacted the police. She wanted them to see firsthand the injuries Eddie had inflicted on her daughter. When they arrived at the mother's home, the officers could see the evidence on Gail of what they described as a severe beating. Gail told the officers that Eddie was responsible. She said Eddie beat her earlier that day at their apartment located on South California Avenue. Based on that statement, don't you think Gail still lived there? The officers did. The officers asked where Eddie was now, and she told them that he was still likely sleeping at the apartment. Gail agreed to take the officers there and to open the door with her key, if necessary. I don't think there's any doubt that Gail knew that the officers were going there to place Eddie under arrest. Gail and the officers drove to the apartment on South California Avenue. Let's be clear, at no time did the officers have an arrest warrant for Eddie Rodriguez, nor did they have a search warrant for the apartment. They were strictly relying on the evidence they had obtained from Gail and her consent to proceed. The officers asked Gail to use her key to unlock the front door, which she did. Once inside, the officers found Eddie asleep in the bedroom. But that's not all they found. They found drug paraphernalia and containers filled with white powdery substances that they believe were cocaine. The officers placed Eddie under arrest and seized the drugs and related paraphernalia. Case closed, right? Not so fast. The officers soon discovered that Gail had no business being in the apartment. Gail had vacated the premises several weeks earlier and had no authority to consent to the entry. She was not listed as a tenant on the lease. She didn't pay rent. She had no authority to be in the apartment without Eddie's permission. She had no authority to invite others into the residence. She possessed the key to the apartment without Eddie's knowledge or consent. Gail was best described by one reviewing court as an infrequent visitor. It would appear that this new knowledge gained by the officers ruined their right to access Eddie's home. The law long ago established that the government may intrude into protected areas if it had consent. It just had to demonstrate that the consent was granted by the individual whose property is being searched or a third party who possessed common authority over the area. Neither of those situations applied. What did apply here was the value and meaning of the words found in the Fourth Amendment. What Eddie Rodriguez and the rest of us is guaranteed by the Fourth Amendment is not that the government will refrain from searching a place without consent, no. Our guarantee is that no search will occur that is unreasonable. In the eyes of the Supreme Court, this means that the government, the officers, act sensibly in the light of facts that are known to them at the time they act. Not that they act responsibly and be correct. Reviewing the facts of this case, Gail's familiarity with the apartment and with the perpetrator, her references to our or their apartment, the evidence of her injuries, and her possession of a key. Did the officers come to a reasonable conclusion that Gail had the ability to grant a valid consent to enter the apartment? I say yes, but let's see what the court said. In what became known as the apparent authority doctrine, the Supreme Court believed that it was possible that the officers acted in compliance with the Fourth Amendment. That is, the officers could have acted reasonably. No less, no more can be expected of them. The Supreme Court sent this matter back to the lower courts to determine if the officers acted reasonably in light of their Fourth Amendment obligations, not whether they were ultimately correct in their conclusion about Gail's actual authority. And the story of the Fourth Amendment continued on. I'm Bill Fallon, and this has been a FLETC Talk.